1996. President Clinton signs a law about insurance paperwork. No privacy rule, no security rule, barely a word about your medical records. So, how did HIPAA become the name everyone associates with medical privacy? The answer is a deadline Congress set for itself, and then blew. This is the full story. This. Health tech frontier. Picture healthcare in 1996. Your medical chart is paper, in a folder, in a cabinet. Change jobs, and your next health plan can dig through your medical history and exclude the conditions it finds. And no federal rule caps how long. Every state plays by different rules. Workers stay in jobs they want to leave just to keep their coverage. Congress calls it job lock. And this, not privacy, is the problem it sets out to fix. The push comes from both parties. Republican Nancy Kassebaum and Democrat Ted Kennedy build the bill everyone calls Kassebaum-Kennedy. Its real name? The Health Insurance Portability and Accountability Act. H.R. 3103 passes with overwhelming bipartisan support, and on August 21, 1996, it becomes law. Portability is the headline. Accountability is the fine print. And the fine print is where this story gets interesting. The law has 5 titles. Title 1, Keeping Coverage When You Change Jobs. Title 2, Fighting Healthcare Fraud, plus a quiet subtitle called Administrative Simplification. Titles 3, 4, and 5, Taxes, Group Plan Rules, Revenue. Notice what's missing. Privacy gets exactly one section, number 264, buried near the end. Hold that thought. First, what the law actually did on day 1. Title 1 attacks job lock directly. A group health plan can now exclude a pre-existing condition for at most 12 months. 18 if you enroll late. Only conditions treated in the 6 months before you joined can count at all, and every month of prior continuous coverage subtracts from the exclusion. Arrive with a year of coverage behind you, and it can vanish entirely. One more detail, decades ahead of its time. Your genetic information alone cannot count as a pre-existing condition. Remember that for Episode 5. Title 2 carries the sleeper, Administrative Simplification. Its stated purpose, make healthcare more efficient by moving health information electronically under national standards. The Secretary of Health and Human Services is ordered to adopt standard formats for 9 kinds of transactions: claims, enrollment, eligibility, payments, even claims attachments. Remember that one? It takes 30 years to pay off. And Congress orders one more thing: security standards to protect all that electronic information. Paper medicine is being pushed by statute into the digital age. Then, Section 264. 5 paragraphs that change everything. Congress knows electronic health data needs privacy protection. It just can't agree on how. So it builds an escalator. Step 1. Within 12 months, Health and Human Services must send Congress detailed recommendations on health privacy. Step 2. Congress gives itself 36 months to pass a privacy law. Step 3. If it fails, the department must write the privacy regulations itself within 42 months. With one floor, state laws stricter than the federal standard survive. That clock is now ticking. The law comes with penalties. Modest ones. Civil fines. $100 per violation, capped at $25,000 a year for repeating the same mistake. Criminal penalties for knowingly obtaining or disclosing health information in violation of the law, up to $50,000 and a year in prison. Under false pretenses. $100,000 and 5 years. Do it to sell the data or to cause harm? $250,000 in 10 years. Keep those numbers in mind. Episode 4 raises them. So, did Congress make its own deadline? August 1999 came and went. No privacy law. The pen passed to Health and Human Services, and what the department wrote next is the reason everyone knows the name HIPAA today. That's the next episode, the privacy rule. The full history of HIPAA series is on this channel. One milestone at a time. This has been Health Tech Frontier. Subscribe for the next chapter.